Tennessee is in session.
Good afternoon and welcome to the Tennessee Court of Appeals. First of all, I want to tell you how much we appreciate you agreeing to participate in oral argument via Zoom. I think it's the best way for us to move forward at this unique time in our history, and we appreciate you participating. I also want to tell you that we do not expect any technological problems, but in the event we have them, everybody just remain calm. We'll get it fixed, and I promise that no one will be prejudiced by any problems that we encounter. Even though we are conducting this argument via Zoom today, all the rules and procedures are applicable as if we are standing in the courtroom today. And obviously that means each side gets 15 minutes to make its oral argument. If you are the appellant, you've reserved rebuttal time with the clerk, you'll receive that rebuttal time. Before we start, I want to introduce this afternoon's panel to you. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
In re Estate of Lester Stokes.
All right, Mr. Exum, we will hear from you, please, sir.
Thank you, Your Honor. And again, may it please court, Charles Exum of the Madison County Bar. I'm here today on behalf of the appellant, Miss Martha Stokes, in this appeal from a matter out of the Madison County Probate Court in the estate of Lester Stokes. The issue on appeal today is the validity and enforceability of a prenuptial agreement which was entered into between the appellant and her deceased husband, Mr. Lester Stokes. Just quickly, by way of procedural background, following the opening of the estate for Mr. Stokes and the admission of his will to probate, the appellant filed a petition for elective share, years support, exempt property, and homestead. The estate filed an answer and a motion to dismiss based principally on the existence of the prenuptial agreement that's before the court today. A hearing was conducted on December 10th of 2020, and the court issued a ruling on February 12th of 2021, dismissing the appellant's motion or her claim for spousal rights on the basis that the appellant did not provide the court with clear and convincing evidence that the antenuptial agreement should be set aside and determined to be non-binding. The appellant filed her notice of appeal on March 2nd, and that brings us here today. Your Honor, the first issue on appeal, the first error on appeal which we've raised is the application of the wrong standard of proof and the improper shifting of the burden to the appellant from the estate, which was the proponent of the prenuptial agreement.
Well, Mr. Exum, let me ask you a question.
Yes, sir.
Assuming that's all correct, the wrong standard was applied and the burden of proof was shifted to the wrong party. What options do we have here in the appellate court?
Well, Your Honor, interestingly, I found a case, and I have to confess, it's a case I stumbled on yesterday. It was not cited in our brief. It's the case of Stansil, Stansil, S-T-A-N-C-I-L versus Stansil. It's a Westlaw case, 212 Westlaw 11260. And Your Honor, that case stands almost perfectly on 4 points. The court's order in that case is almost identical to the order in this case. The court applied found it used a clear and convincing standard of proof, and the court shifted the burden to the party trying to set aside the prenuptial agreement. And in that case, the court did reverse, and the court did engage in a Rule 13D de novo review of the record to determine if the evidence preponderated against or for the enforcement of the prenuptial agreement.
All right, if you would, please, sir, if you're going to rely on that case, please send the appropriate pleading citing this as supplemental authority so Mr. Pride can also have it as well.
I will certainly do that. I will certainly do that, Your Honor. But I would point out to the court that the appellees in their brief have essentially acknowledged that the improper standard of proof was applied and the burden was improperly shifted. So while I will certainly supplement my brief, I think that that's an issue that may not need a lot of discussion before the court beyond the court's authority of what can be done after that.
Well, I guess my other question is, I'm assuming the record is complete enough for us to engage in some review of the record and make a determination, but is it proper and appropriate for us to do that, or should we remand to allow the trial court to fix its own problems, assuming there are problems?
Well, and again, Your Honor, relying on that Stansel case, I do believe it's within the court's authority to have a de novo review and make a determination here. I will note that Justice Cesano in the Stansel case addressed your concerns in a dissent, but the majority of the decision was to review under a de novo standard.
Okay, thank you.
Mr. Exum, in this case, is there any proof in the record about your client's independent knowledge of the decedent's assets prior to signing the prenup?
Your Honor, the record is absolutely devoid of any such proof.
Well, if the record is devoid of that, how would we make a determination about whether or not to enforce the prenup? But let's assume we agree with you in improper standard of proof. And looking at the prenup itself, it doesn't fully disclose all of the assets. But the next step is for a determination of whether or not the party who signed had independent knowledge of assets. If that's not in the record, how would we decide that?
Well, Your Honor, the burden of proof, again, being on the proponent of the antenuptial agreement, that burden is upon them to present the proof at trial. And if the proof is not presented at trial, then this court will have to look at what was proven and what's in the technical record as far as the substance of the agreement, the disclosures that were made at the time of the agreement, and absent some proof that would substantiate independent knowledge on the part of the appellant of the extent, nature, and value of the estate, then I think the court would have to find that the proof preponderates in favor of the appellant's assertion that the agreement shouldn't be enforced.
Well, the judge never got to that because the judge applied an improper standard. So it never went to that next step, did it?
Well, Your Honor, I would simply say that the record, there was proof put on that day regarding the execution of the agreement, the time frame leading up to the agreement, the signing of the agreement, and it would again seem that absent some proof on that day, the court didn't have proof in front of her to substantiate a finding in favor of the agreement, Your Honor. So I guess it would be my position that you have your opportunity on the day of the trial to put on the proof that would support your position, i.e. that from the appellee standpoint, that the agreement should be upheld. And so it's incumbent upon them to put on that proof. And if it's not presented to the court, then this court, in reviewing the proof that was presented, would have to find that the preponderance of the evidence is in favor of the appellant.
Okay.
Let me change gears on you just a minute, Mr. X.
Yes.
It appears that in the partial review that I've done of this record, the main concern for everyone are the two homes. Is that correct?
Yes, sir. In fact, Ms. Barnett, the attorney who drafted the agreement, stated that was what she was told by her client, Mr. Stokes.
Is there any authority, or is there any can you have a partial waiver here? Can it apply only to the homes, or is this an all or nothing proposition?
Your Honor, from everything I have seen, this is an all or nothing proposition. I have not, if you look at the language of the statute, which is 36-3501, it talks about the enforceability of the agreement. It doesn't give us any guidance from the standpoint of partial enforceability as to assets. I do think it's an all or nothing proposition, and I have found nothing in Tennessee case law that would support a partial parsing of assets based upon what was actually disclosed in the agreement.
Okay, thank you.
Your Honors, I guess, and actually this is kind of addressed what I was getting to. The factors in this case, without going through all the facts, I mean, you've got a situation where the parties met in March of 2014. They got engaged in December of 2014. They set a wedding date for June 17th of 2017. This was going to be a big wedding, even though it was their second wedding. They had 350 guests. They had caterers, florists, musicians, the whole 9 yards. And not until approximately 2 weeks before the wedding date, was there ever any mention to the appellant of a prenuptial agreement. And she was presented with this blank form sample antenuptial agreement, which was basically an asset worksheet. And it's in the technical record at pages 87 and 88. And she filled that out. 5 days before the wedding, they went to the law office of Sarah Barnett, who was Mr. Stokes' attorney. The agreement was signed on that day, and she was presented at the time of signing again with these financial disclosures, which the court has alluded to. And again, I'd point the court to the technical record at page 48 for Mr. Stokes' agreement. It listed the house, an approximate value of the house, an estimated amount of the mortgage, and a statement of the yearly income, which was supported by a check stub and a tax return. As I noted earlier, Ms. Barnett expressed concerns and she testified that she expressed the concerns to her client that this was not going to be sufficient, and there could be some issues with the enforcement of this agreement under those circumstances. That being the case, they went ahead. The agreement was signed. Ms. Stokes, the appellant, did not have independent counsel on that day, and it was based upon this skeletal worksheet of assets. Parties got married on July 17th as scheduled, 5 days later. And then after about a 2-year bout with cancer, Mr. Stokes passed away on August 26th, 2019. Your Honors, we've gone over the issues on why we believe that the agreement and the disclosure that was submitted with the agreement is not sufficient. When the estate was opened, the personal representative filed an inventory, first of all, disclosing about $26,000 worth of personal property. At the hearing, when questioned, the personal representative testified that there was a 401k with TVA, which at this point, we don't know the value of that because we did not get that far into the proceedings where discovery really got to those points. But there was a 401k. There was approximately $300,000 in cash on deposit. There were life insurance policies, all of this over and above what was disclosed on with the prenuptial agreement. So, Your Honor, we support that disclosure was clearly deficient. And then beyond that, Your Honor, going back to what Justice Armstrong was asking me about, there's nothing in the record. There's no proof that would support independent knowledge of the extent of the appellee's wealth. There's no proof of banking that he discussed with her with bank accounts. There's no proof of any discussions between the parties during their engagement of assets, business matters, financial holdings. No proof that she had access to or was able to review financial records, or that his assets were really even of a nature that from a simple observation, she could attain the information needed to have full, fair disclosure of the nature, extent, and value of his assets. So, failing the sufficiency of disclosure and failing any proof of independent knowledge, it's our position, Your Honor, that this prenuptial agreement has to be set aside. Thank you.
Thank you. Mr. Pride, we will hear from the appellee.
Yes, sir. Good afternoon. I represent the estate of Lester Stokes, and obviously this is not the typical prenuptial agreement case.
Mr. Pride, I need you to introduce yourself. I know who you are and everybody else does, but we're recording it.
All right, Nathan Pride, Madison County Bar Association. I represent the estate of Lester Stokes and the executor thereof. Thank you for giving me the opportunity to make this argument on behalf of the estate. Again, this is not the typical prenuptial case. It was a very difficult for the court to try to digest this, mainly because we were missing one part of that being Mr. Stokes. In this particular case, it came down to the matter of credibility. And the court found that Ms. Stokes simply was not credible in her testimony. The testimony of Ms. Stokes could not be challenged to any great degree because she could say anything. She could say he forced her. She could say that she did discuss it with her. She could say a lot of things, and she said that with no way for the estate to prove otherwise, because the court had to rely upon her testimony, and we had to rely upon her testimony. But even in doing so, the court found that Ms. Stokes simply was not credible, and found that the agreement should be enforced as the only asset that either one of them was concerned about, which was their homes. Ms. Stokes,
Right. Let me ask you a question before you get too far. Now I'm looking at the order denying claim for elective share and so forth, and I'm also looking at the statement of the evidence. Where did the court not find the appellant credible?
well, I don't think the court said that specifically, Justice, but the court obviously, from the testimony of Ms. Stokes, had to make that determination because it ruled against her. And she being the primary witness, the only other witness of very brief nature was one of the executors and Ms. Sarah Barnett, who prepared the agreement. And so the sole witness was Ms. Stokes. And obviously she did not convince the court by the abundance of the evidence or even the standard that the court applied that she was correct in her understanding of the agreement. It was clear that Ms. Stokes had sufficient knowledge to understand what she was doing. In fact, she was asked directly. The problem with our record here is that we don't have a transcript, but she was asked directly if she understood the agreement, if she understood the contract, and she said, yes, she did. She was a college graduate. She attended.
Did the court find that she understood the agreement?
I don't think the court in the order, Your Honor, the judge didn't issue specific findings of fact and law in this case. The order was prepared by the attorneys, I believe, and I'm not sure even just from my memory of it, Mr. Exum may correct me on this, the judge in her national ruling used that standard, but it was put in the order and that's what she signed, so therefore that's what we have before the court this afternoon. So that's what we have to go with. But obviously there was some disturbance to the court that Ms. Stokes was not convincing to the court that she did not understand what she was doing. She did not understand what Mr. Stokes wanted her to do and why. When clearly she did. Again, the agreement lists home for each one of them. It lists their income, and that's all. She did not disclose her 401ks, her retirement, her insurance, her other assets either. So she could be worth $1 million. He didn't know it, but
let me ask you: when parties execute a prenup and they fail to make a full disclosure, is that agreement enforceable?
To the assets that are listed on it, I would think that it is.
I'm sorry, say that again.
To the assets that are listed thereon, I would think that it would be. In this case, the homes of both Ms. Stokes and Mr. Stokes. But again,
Well, you say to the extent that it covered a particular asset, it's enforceable.
yes.
Well, what about these other matters now that are being litigated in probate? Since
Again, Your Honor, that's questionable. They're actually not being litigated in probate. The assets that I think Mr. Exum is making reference to when asked the executor, I believe, passed outside of probate. The only asset of the probate estate of Mr. Stokes was a house on Colonial Drive and furniture on Colonial Drive. That's the only asset of the estate. So anything else, we don't know about. And we certainly did not know at the trial of any assets of her, nor she could close it.
Let me ask you, after the hearing in December, did the trial court rule at that time?
I believe the court ruled immediately after the hearing on the issues.
The court make a full ruling in December after the trial.
Correct. It made it after presentation of all witnesses and argument of counsel, it made the ruling.
I'm sorry, was that a yes or no? I can't.
Yes,
She ruled. And who prepared the judge's order, Mr. Pride?
I believe I prepared it. I can't recall if Mr. Exum prepared any part of it or not. I know I was involved in the preparation of it.
So the order that was filed is an order that was completely prepared by you. Is that right?
I'm not sure, Your Honor, if that's correct or not. I recall writing Mr. Exum about making some changes, or he had some problems with the order, but I cannot remember specifically.
So you don't remember whether the judge made changes in what you prepared or not?
No, sir. I do not believe that she did.
Okay.
Again, the standard that I tried to find cases that were on point with this particular case, those that involve a deceased party where the estate had to recreate or try to supplement the testimony of that person. I could not find one on point. The three cases I did find, I cited in my brief, all dealt with cases that initially were divorces and then the person died and there was some question about the business owners. But I could not find one on point as to this particular case, where parties had dated for a number of years, married, and divorced and married previously. And the only person to testify was the proponent, the person who was proposing that the agreement not be enforced, which was again Ms. Stokes. So obviously, the court, in weighing her testimony, could not find that testimony was credible, and found that the agreement should be enforced again as to the homes that they listed their own. Using the standard set forth in Randolph, which required that she have some knowledge. Clearly, she had knowledge of those assets. When questioned about those, Ms. Stokes was vague about whether or not they discussed it. 2 years that they were married, it's just not there. And again, because there's no way for the estate to say, have someone to testify that she's not telling the truth or this is incorrect. The court had to rely simply on the testimony of Ms. Stokes. And so the burden didn't necessarily shift, but the burden was just there because the only person that they could use was her. And obviously, we felt on cross-examination, the court felt that her testimony was not credible and therefore found that the agreement should be enforced.
Yeah, Mr. Pride, looking at the statement of evidence, I don't see that there's any indication there was any proof put on about Ms. Stokes' knowledge of Mr. Stokes' assets prior to executing the prenup. Can you cite to me anything in the statement of evidence that addresses that issue of what she knew before she signed?
The only thing that's in the record is the document that Attorney Barnett gave to them in advance, which was a worksheet. When they bought the worksheet back, they bought it in the condition that it was. They only listed the homes and they only listed their income. She gave them the full sheet, which had lots of asset categories on it, but when they bought it back, they made the decision to only put on there the home and their income. So that was the choice of Mrs. Stokes, and apparently the choice of Ms. Stokes. And the attorney advised them that anything beyond the houses may not be enforceable. So they understood that.
You say they made the decision. Was there any evidence about that in the record? I don't see anything in the statement of evidence other than the fact that that's all it was.
The only thing in the record, Your Honor, would be the fact that she turned in her income and her home, and he turned in his income and his home to Attorney Barnett.
Okay, thank you.
So obviously, they acted, and we were thinking in good faith as to that asset. Again, because we were not able to put on Mrs. Stokes to refute that they discuss it every day, or why they only listen to home, because I believe he made it clear to Ms. Barnett, and she testified in the record, did Ms. Stokes, that they were concerned about the homes going to their children. I think Mrs. Stokes had 4 children, Mrs. Stokes had 1 child, and all were adults, and they were concerned about that. And I think the agreement is enforceable as to their asset. There's no proof of duress in the record. Ms. Stokes testified that the marriage was pending, but we could not verify, the court could not verify that he promised not to marry her or said, I wouldn't marry you if you don't sign this. Ms. Barnett did not testify to that effect, and therefore we felt that, again, she had adequate knowledge, she acted in good faith, both parties did, there was no duress, and again, it comes down to matter of veracity of the witness in this case, which again was Ms. Stokes. The Randolph case talks about sophistication of the agreement. This is not a very sophisticated agreement. It did take neither one of those parties very long to understand that they were assigned an agreement, understanding that it was concerning their homes, that each wanted their children to receive. And so it didn't take her a week, or would not have required her days or weeks to do so. I specifically asked Ms. Stokes on cross-examination about her understanding of the agreement. The first paper says, I waive certain rights, I understand certain things. She said, yes, I do. And I did at that time.
Now, wait a minute, Mr. Pride. We don't have a transcript. We're stuck with whatever the statement of the evidence says, don't we?
Yes, sir.
Can you point me to where that is included in the statement of the evidence, please?
It is not.
Okay, so we don't really need to be talking about anything that's not shown by the pleadings or the statement of the evidence.
That being the case, Your Honor, she was cross-examined under oath, and the court again found her testimony not to be credible based on that cross-examination. Again, there's no list of any assets from either party other than the home and their income. The freely waived her right to counsel and or further review the agreement which she signed on the day of Ms. Barnett's office. So again, she understood that. Now, as I was saying earlier, this is not a person who did not understand the business transaction. I believe Ms. Stokes testified that she not only had a business degree, but had worked in a business office for over 20 years, dealing specifically with contracts, and she understood what she was doing. TCA 36-3-501 talks about the discretion of the court. As part of its elements, we believe in this particular case that Judge Little, using that discretion and based on the testimony that she heard and the proof that was presented to her, did correctly rule that the agreement should be enforced. And the only asset there being, and the only thing that the court had to deal with was a home, and therefore the court's ruling so found. Using that again as a basis, we find that this agreement was signed freely, voluntarily, knowingly, without any duress or promise on the part of Mr. Stokes that we could detect or determine, and therefore the same should be enforced by this court. And so we're asking the court to find that Judge Little was correct in her ruling. Even if she had used the preponderance of the evidence standard, it would still been the same result, and therefore this court should find so on a de novo review of this. Thank you.
Thank you. Mr. Exum, we will hear from you in rebuttal, please, sir. There you go.
Thank you. Your Honor, first of all, and I want to apologize, the audio on my end was not clear, so if I'm repeating anything or addressing something that wasn't raised, I apologize. I do think I want to clarify for the court in response to Judge Armstrong's questions. Judge Little, in this case, did rule from the bench that day, and her ruling was substantially the same as Mr. Pride included in his order, and that order was drafted by Mr. Pride. I did not participate in the preparation of the order.
And Judge Little used the burden as being clear and convincing on the party opposing the prenup. She
Your
said
Honor,
that. in the oral
As
ruling.
I'm gonna sit here right now, I can't tell the court I remember that. I do remember the burden was shifted. She said that Miss Stokes had not convinced her that the agreement should be set aside. And I can't, as I sit here right now, tell the court honestly that I remember the standard of proof.
Okay, all right.
Just very briefly, I would point out to the court, because this again, Judge Armstrong addresses something you asked me earlier about the lack of proof as to knowledge. I would direct the court to the estate of Baker versus King, 207 Southwest 3rd, 254, which I do believe is cited in the appellee's brief. And that was a case where the trial court, on a credibility basis, discounted entirely the testimony of the wife seeking to set aside to avoid the enforcement of the agreement. And so the trial court followed that lead. They did not take into consideration anything that the wife testified to, yet they then went on to say that there was no evidence in the record sufficient to establish the independent knowledge requisite to support the agreement. So you'd asked me about the lack of proof. I would say that supports our position on all fours. And I think I'm now out of time, so I'll stop.
All right. Thank you. Thank you both. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We again appreciate you participating by Zoom. Ms. Angie, if you will recess court to the call of the next case, please.
This honorable court is in recess until 2 p.m.
Thank you, gentlemen.